I'm looking at my hair. It was straight when I left this morning. That
You
rain,
did,
that
yeah.
rain changed that. Novak.
Good morning, Your Honors, and may it please the Court. We submit that this appeal starts and should end with a very basic causation principle. Sometimes it's called loss causation or proximate cause or just causation. Under that principle, damages for fraud cannot be awarded if the damages would have been suffered even if the defendant's representations were true. The rule is well established under Illinois and Seventh Circuit case law, and we cited 5 cases demonstrating the point. Here, the only fraud damages sought by plaintiffs and the only fraud damages on which the trial court instructed the jury were those that allegedly resulted from plaintiffs not acquiring the subject house. Yet, and here's the point, because plaintiffs themselves voluntarily elected to terminate the contract under the mortgage contingency clause, plaintiffs would not have acquired the house even if defendants' representations as to the condition of the house and the status of construction had been true.
That sounds like a but-for causation argument to me.
It's really not, Your Honor. Even if there's but-for causation, plaintiffs wouldn't have gotten into the contract but for the misrepresentations. Loss causation goes a step further and says, well, would the alleged damages have been suffered even if the representations were true? In all those cases, we cited 5 cases.
Mr. Novak, forgive me. The plaintiffs presented evidence that they never could have gotten a mortgage approval by the date in the contract because no company would give a mortgage on a gutted property. Why wouldn't that be sufficient right there to show that Farragut's actions caused the problem, hence it caused the resulting damages? I mean, it all relates back to the permit issues and the stop work order. Not anything, it would seem, that the plaintiffs did or failed to do. That's my problem.
Your Honor, that is exactly the argument the plaintiffs are making, but it's argument, and it rewrites the evidence. They cite to Ewing's testimony to say that they couldn't have got a mortgage commitment, but look at his testimony. His testimony was that he heard from mortgage brokers that you cannot get a mortgage, not a mortgage commitment. He said you cannot get a mortgage if the property is not, if the home is not ready. He didn't say that you can't get a mortgage commitment. We all know, come on. Every day mortgages are given, mortgage commitments, I should say, are given on uncompleted houses and before the purchaser even gets title. It's a step to getting a mortgage. It's not the mortgage itself. And the very next page of the transcript at 230, docket 310, 239, 12 to 15, then continuing on line 23 on to the next page, 240. Here's the reason that Ewing testified under oath. In fact, in questioning by his own counsel at the trial, here's what he told the jury. Question, did any of those lenders offer any type of a mortgage to you? Answer, one lender, Mr. Hoppe at Stearns Lending, said that he could proceed with the mortgage application in just my name. And was Mr. Hoppe willing to provide a mortgage commitment to you in both of your names? In both of your names? Answer, no. Did you proceed with that application? No, we did not. Why not? Our understanding was that the contract required the mortgage commitment to be provided to both of us. So Mr. Ewing and Mr. Gomez stopped the mortgage commitment issue right in its tracks. Wouldn't even put in an application for the loan. It is purely hypothetical, Your Honor, if I may. Purely hypothetical whether there would or wouldn't have been even a mortgage commitment issued because it wasn't applied for. That's what happened.
Why
And
didn't
that-
your client get a mortgage?
Pardon?
Why didn't your client get the mortgage?
Our client directed the plaintiffs to Mr. Hoppy
And why didn't Mr. Hobby give them a mortgage?
because they didn't put in an application for it, because he said the only way we're going to proceed with this loan is if Mr. Ewing, only you, we don't want Mr. Gomez on the document. And Mr. Ewing, maybe understandably, said, I'm not signing up for this without my partner being liable as well.
Under the terms of the contract, was that enough for your client to just point them in the direction of a mortgage broker? Because I thought the contract allowed, if Mr. Ewing and Mr. Gomez could not get a contract, then it was up to or a mortgage, then it was up to your client to get them a mortgage. He had a certain period of time in which to get them a mortgage, and he did not do that either. There was no mortgage.
He had no obligation to do it under the contract. Paragraph 2 of the contract says if the plaintiffs cannot get a mortgage, at the defendant's sole option, can elect to try to get it. And if he gets it, that's good. If not, contract is over.
I don't recognize this as a loss causation argument. It sounds like an argument about who breached and has nothing to do with the fraud. The fraud in this case was the permitting deceit by your client. That's well established, no question about that. And that's not even being litigated on appeal or relitigated on appeal. So
Well-
the fraud damages are those losses that flowed from the permitting deceit by your client. The breach of contract was a separate claim, although the damages instruction, as I understand it, on both the contract claim and the fraud claim were identical.
And Judge, respectfully, the verdict form that the jury signed found no additional damages, 0 additional damages on breach of contract. The breach of contract damages were the earnest money, and they checked the box, no additional damages for breach of contract. They
Right, so
then checked.
I understand that. And the whole argument you're making here about who failed to get the mortgage and why is totally related to the breach of contract claim. It has nothing to do with the fraud claim. The fraud claim is about the permitting deceit.
First of all, we're not claiming on this appeal that the plaintiffs breached the contract. There was no.
I understand you're not relitigating that. That's what I just said. That either as a fraud concept or as a breach of contract concept.
Yes, but the point is, Judge, maybe I just was completely unclear and I apologize. Fraud damages were awarded, no contract damages beyond the
Understood.
instructed damages.
Understood.
So the question is, can those fraud damages, not breach of contract damages, can those fraud damages stand when they all stem, and the plaintiff's brief admits that all the damages are triggered by the fact that they didn't get the house. Every one of them comes from not getting the house. And the loss causation argument is, but they wouldn't have gotten the house anyway because they couldn't get a mortgage. And by the way, they could have continued with the contract without the mortgage commitment, but they elected to terminate the contract.
But that's a jury argument. I mean, there's evidence in the record. There's clearly evidence in the record from Mr. Ewing that he testified that he met and had meetings with mortgage brokers. And at these meetings, he was told that he couldn't get a mortgage commitment because the home wasn't ready to be lived in, and they couldn't get a mortgage until the home was ready. That's it. I mean, the jury believed that.
But it doesn't matter why he couldn't get the home. Just because the home wasn't completed, that doesn't prevent somebody from getting a mortgage commitment.
Well,
And that-
according to Mr. Ewing, it did.
Right.
No,
That's what he testified
he
to.
did not.
Well, I understand.
Respectfully,
I
he
get
did
it. That's
not.
okay. You can argue.
He did not testify to that. He said, I was told by 3 brokers that you can't get a mortgage, not a mortgage commitment. There's no testimony about a mortgage commitment. And that's the only thing that triggers that clause. He said he was told by 3 brokers he couldn't get a mortgage until the home was ready. Didn't say because lack of permitting or because of fraud, just the fact that the house wasn't done. You can't get a mortgage. That probably makes sense. You can't get a mortgage. You can get a mortgage commitment. Everybody gets mortgage commitments in advance. And then they're subject to conditions, et cetera, et
But
cetera.
why was the house not done?
The house-
Because of the permitting deceit.
permitting problem, but loss causation
Not problem,
assumes.
permitting deceit. This is a deceit case, a fraud case.
But with
Your
all
client
respect,
concealed the permitting, the lack of permitting, and the city wasn't going to allow any further construction until that issue was addressed.
and if the plaintiffs had not terminated the contract, they could have perhaps sought and obtained those damages. But once they terminated the contract, that meant they weren't ever going to get the house. Not because, and they didn't get the mortgage, not because of the condition. They didn't make a loan application, had nothing to do with the condition. It was because of who had to sign. And let me assume for a moment that the reason they didn't get the mortgage and the reason they gave the termination notice was because of fraud. Let's say that is. The RoboServe case, this court's case, cited in both parties' briefs, says that if a party is induced to sign a contract under fraud, the party has an option, and only two options. It can affirm the contract and seek all these damages, benefit of the bargain damages, et cetera, or it can rescind the contract, in which case it's limited to monies paid in performance of the contract. That's the earnest money, and only the earnest money. That's what the RoboServe case, that's Illinois.
The
that's
problem with
Illinois
that
law.
argument is that you approved the instructions, the jury instructions on damages. And
But the
this argument about the measure of damages that you're making on appeal was not preserved below.
Oh, we make a causation argument,
I'm not talking about the causation argument, I'm talking about the measure of damages argument.
but that's not,
That's a measure,
Respect-
the argument you're making now
It's
is a
not-
measure of damages argument about how to measure the fraud damages, either benefit of the bargain or out of pocket. And that's a complicated question under Illinois law. There's all kinds of restatement rules that apply to that evaluation. And there's no possible way a district court judge is going to be held responsible by an appellate court for the kind of instructional error that you're now alleging on plain error review when you approved the instructions and in fact requested them.
Judge, trial counsel approved an instruction for damages that included a causation element.
Mr.
They could have
Novak,
listed
do you think it
15,
would-
they could have,
do you think it would help us if we talked about the emotional distress damages for a minute? Because time is moving, and Farragut has complained that the court failed to instruct the jury on what the plaintiffs needed to prove to establish the emotional distress damages. But Farragut asked the court to remove that information from the instruction. So I've been trying to figure out how that would not be a waiver of that issue.
Farragut did, respectfully, Farragut did not say remove that. Farragut said we object to any instruction whatsoever. There should be no instruction on emotional damages. The plaintiff did not come close to the severe standard of care, standard of proof for emotional distress damages. And then said, but if you're going to put it in the instructions, then just put in emotional distress. But the fact of the matter is, the standard wasn't met. No matter what that instruction was, the standard of proof, and we cited the cases that say it, only if the distress inflicted is so severe that no reasonable person could have been expected to endure it. There's no evidence like that in the record. And they got at least $210,000 of emotional distress damages on a failed sale of a house where they kept their money. They didn't pay a penny beyond the earnest money and are getting $800,000 of damages. That's, in the words of the court, monstrously excessive under the circumstances. This is
Well, think, speaking of keeping the money or getting the money, Farragut complained about that 5-year time frame for some of the damage calculations. But Farragut held on to the earnest money for that period of time. So even if Carrier, even if he reasonably believed he was entitled to keep the earnest money as liquidated damages, why would Farragut not be liable for damages for every minute of delay after the court ruled that the liquidated damages provision was an unlawful penalty?
Well, that's a question of loss of the use of the money, and the law provides the remedy for that, which is prejudgment interest. Prejudgment interest was not requested or awarded, could have been, and under the law, that's what accounts for not having the money.
Meanwhile, everything that that they had seemed to be tied up. So,
Judge, I'm 3 minutes into my reserve time. May I reserve the last 4 minutes for rebuttal?
Yes, you may.
Thank you.
Thank you. Mr. Ewing.
Good morning, Your Honors. May it please the court, Randall Ewing for the plaintiffs, cross appellants and appellees. I'd like to point out a couple of factual issues that I believe my colleague misstated. It appears my colleague was confusing the difference between a mortgage pre-approval letter and an actual mortgage commitment. This was all explained by Mr. Hoppy's testimony at trial. A mortgage commitment is a firm commitment to lend that says, everything has been satisfied, we're ready to give you your money.
For a particular property.
Correct.
Not just, the mortgage letter you're describing is you go to the bank and you tell them, I make $200,000 a year, whatever it is. And they give you a letter that says, we will give you a mortgage in the amount of $500,000. And then when you go meet with a real estate agent, you show him or her that letter and they show you properties that they think can fit your budget. That's a mortgage letter that you're talking about, right?
That's right. And that is different from an actual mortgage commitment, which is usually issued a couple days before closing once it's gone through underwriting, as Mr. Hoppy explained. It was also an undisputed fact to address Judge Rovner's question about whether a mortgage could have been obtained no matter what. That was an undisputed fact found by the district court and enforced under Rule 56G. Mr. Hoppy also testified at trial that had he known the house was gutted, he would not have been able to issue a mortgage commitment during the time frame required. As to causation, there's two elements of causation. Was the conduct a material and substantial factor, and was it legally foreseeable? That second element's sometimes called like legal risk. They have never challenged the second element. They've only ever challenged the first element. And it fails for two reasons. First, the letter in October 2016 was not accepted. They did not accept the letter. They said it was not invalid. We are terminating the contract and we're keeping all your money. So what the defendant is trying to do is now, 5 years later, after being found guilty by a jury, is trying to go back in time and say, actually, that letter you wrote in October 2016, I'd like to abide by that.
Right, and doesn't all that simply relate to the question of who breached?
Yes. And the
rather
jury,
than what the loss from the fraud is and how it's measured, which are separate questions.
Well, I do agree with the general premise that if the misrepresentations had been true and we would have walked away from the house anyway, that there would be no damages based on acquiring the house. As a legal matter, that's correct. The problem is that's not what happened in this case. The mortgage could not have been obtained no matter what, so that satisfies causation. In addition, even if that October letter were relevant in any sense, there was testimony that it was defendant's fraud that caused that letter. And the law is quite clear whether you call it an intervening cause, a superseding cause, a third-party cause. If the defendant is trying to point to some other event and say that event breaks the chain of causation of damages, then that fails if the defendant actually influenced that event. So the plaintiff sending the letter in October 2016 does not reflect the but-for world. At that point, the defendant had refused to enclose the balcony, which the court found was fraudulent and breach of contract. Defendant was imposing damages and trying to claim their earnest money for delays that were being caused by completely unrelated parties. That was unlawful. So October 2016 does not reflect the world if the misrepresentations had been true.
I'd like to go back into the size of the emotional damages, please, if I might.
Certainly.
What is the best evidence supporting the size of those damages? Because I fully understand that, you were prevented from buying a house for 5 years because your liquid assets were tied up. And it was the defendant's false accusations about the cause of the delays that led to some relationship problems. Is there anything else that justifies that amount that you can elucidate on?
Well, one of the biggest pieces of evidence which the district court relied on when having firsthand observation of the trial affirming this award, as the district court noted, one of the biggest pieces of evidence was Mr. Carrier's testimony. As we submit in the brief, and I believe as the district court alluded to, the testimony was not favorable to Mr. Carrier at all. He was impeached multiple times. He said things that were directly contrary to emails that were shown to the jury. And the district court noted that the jury was able to observe that conduct and then determine, it's essentially gaslighting, and then determine what would the emotional distress be of having your life savings held up by someone who's consistently gaslighting you.
Was the jury given any instruction at all as to how they should consider emotional distress?
Well, we proposed one.
And it was the defendant who, as I look at the judge's factors, is that you may consider the following factors of damages. Fourth, emotional distress. That's it. I mean, I don't know what a jury's supposed to do with that without any more information. And it seems like in this case they decided to do with it in your favor.
Yes, there was additional language in there in what we had proposed that matched the model jury instructions about the different elements that go into it, and the defendant said, we would like that additional language removed.
I mean, I think the defendant's argument on what's required for emotional distress damages in this case is correct, but you can't invite error and then complain about it on appeal, I think is your argument.
Exactly, and it's not even plain error.
Right, it's waived. You can't
there's
invite
a difference
error.
between forfeiture and waiver. Waiver forecloses appellate review. If you just fail to object, plain error. If you actually advocate for the position, appellate review is foreclosed entirely. Now, they do have an argument that they did object that the basic standard to award any emotional distress damages was not met. And they keep pointing to this of a severity that no reasonable man can endure. But that's just not the standard in Illinois when you have torts that have other economic damages. They point to a couple intermediate appellate court cases from 20 years ago. The Illinois Supreme Court, as we noted in the brief, spoke to this in 2017 in the Cochran versus Securitas Security Services case. And it said plaintiff's claims here fall into the category of cases in which a tort has already been committed against the plaintiffs, and they assert emotional distress damages as an element of damages for that tort. And if you read the case, it's a long discussion about when you have to meet the severity standard and when you do not have to meet the severity standard. And when you have a tort with other economic damages, there is no severity standard, certainly not that no reasonable man can endure.
That's just for standalone emotional distress damages?
I'm sorry?
That's
Your
just
Honor?
for standalone emotional distress
Yes,
damages
yeah,
where there's not
if-
underlying economic
Yeah,
damages?
yes, Your Honor. If there's either a claim for intentional infliction of emotional distress or if you have some other tort that has no economic damages, then you have to meet that severity in order for the claim to proceed.
Mr. Ewing, on the admission of the Fruit Cups comment, the court admitted it for punitive damages, but later ruled that punitive damages were not available. And that language, of course, came to light during the litigation, not during the parties' dealings with one another. Do you see, what would the relevance of that be, do you think, to the fraud and breach of contract claims?
Well, Your Honor, punitive damages are appropriate if the defendant commits the tort with malice, ill will, spite, or an intentional disregard of the plaintiff's rights. And the relevance of that email was it showed malice or ill will towards plaintiffs at the time he was committing the fraud. The defendant keeps claiming that it's completely unrelated, has nothing to do with the fraud. The email he was forwarding to his counsel was an email to us that contained fraudulent statements about his ability to work on the house. The next time we heard from either Mr. Carrier or his attorney following the Fruit Cups email was a letter saying they could work on the house, which was wrong. The attorney later testified he wasn't actually aware of the permitting issues at the time. So this Fruit Cups, this belief, denigration of plaintiffs in Mr. Carrier's mind was in his mind at the exact same time that he was committing the fraud and doubling down and tripling down on the fraud over and over again. So that's why we believe it's relevant to punitive damages. We also believe it's relevant to emotional distress damages because we discovered the email in May 2018, and at that point, our life was still in Mr. Carrier's hands. So the defendant keeps trying to paint this case as a case that stopped and ended, started in April 2016 and ended in October 2016. It wasn't for plaintiffs. It might have been for defendant when they walked away with the house and the money, but for the plaintiffs in 2018, when they discovered that Mr. Carrier viewed them as quote unquote fruit cups, Mr. Carrier was still largely in control of their life and ability to buy another house, and that caused additional emotional distress.
Can you attempt to isolate what component of the damages award the jury probably allocated to emotional distress damages? Because this is speculative in a certain sense because there were not line item breakouts of each component of the damages other than the earnest money that had already been awarded as a matter of law by the court. So there's additional damages over and above the earnest money in the amount of $787,500. And you were asking for specific amounts in the other categories of damages, correct?
Well,
$200,000 for the cost to purchase a new home, the increased cost to purchase a new home.
Yes, that's the maximum amount that was put into evidence on that category of damages.
And then how much to rent a similar house for the 5 years that you were
would
with?
have been $350,000, $5,000 a month for 60 months.
Okay, and then $25,000 in actual rent paid?
It was the instruction was one or the other.
Okay,
Yeah,
so we don't really know what the jury did there?
Yeah,
Because that's either a big ticket item or a small ticket item in this total.
I agree, but I believe based on the evidence that was introduced into the jury, I'll acknowledge that I think there had to be a minimum of approximately $225,000 emotional distress because there was not evidence of economic damages above and beyond, around $552,000.
Okay, thank you.
Mr. Ewing, Farragut is bankrupt, correct?
That's my understanding. They keep being able to. Well, yes, that's I'm sorry. Let me correct that. I don't believe they're bankrupt. I certainly haven't been notified of any bankrupt filings, but I believe it has no assets.
Insolvent.
Right.
Yeah.
Okay, so if we agree with you, will this just be what kind of victory will this be? I mean, will it be, I mean, are you, yeah.
Two things, Your Honor. First, we have an appeal. We twice tried to amend the complaint to add Mr. Carrier to the case after discovering his fraud, which included abuse of the discovery process itself. If Mr. Carrier is added to this case, he would be issue precluded. He personally made the fraudulent misrepresentations, and under Illinois law, whether you're an officer of the corporation or not, if you personally participate in the fraud, you're personally liable.
But on the cross appeal, I mean, what exactly was the court's abuse of discretion in declining to allow that late amendment? I mean, I understand that this could have gone the other way, but what we would have to find is that no reasonable person would have ruled this way. And I'm not sure that I can see that level of a problem. The plaintiffs ran out the discovery clock, and then, you asked to add the defendants to the case. So where would the abuse of discretion be here?
Well, I believe the law provides that it is an abuse of discretion to entirely fail to consider a relevant factor that's relevant under the analysis. And I believe the district court abused its discretion by not really considering at all the fact that Mr. Carrier had abused discovery and caused the very same prejudice that it was complaining of. There was no analysis of his discovery responses. There was really no addressing that at all, other than to then say, well, you waited 3.5 months after that, even though it found that there was no, it didn't make the district court did not make a finding of undue delay. So I believe it was an abuse of discretion. I don't think this court or any court should reward parties who abuse the discovery process to hide claims.
Why can't you just proceed under Rule 69? We issued an earlier opinion in the related case in front of a district judge, sending this back to Judge Coleman, and said, look, if the judgment against the LLC becomes final, plaintiffs could enforce that judgment against any alter ego in collection proceedings under Federal Rule of Civil Procedure 69. Wouldn't that work here?
Well, we did try to do that following that opinion, and the district court.
She just held everything, right? She just stayed it pending.
No, in this case.
Right, right. I thought she held everything. She doesn't have jurisdiction of this case right now. We do. So everything is on hold in the district court, as I understand it.
I need to think about that. That's a good point. I'm not sure if the district court is divested of jurisdiction of supplementary collection proceedings, but we did move following that opinion to pierce the veil in supplementary proceedings.
I got it.
And the district court, following several Seventh Circuit opinions, have said that under Illinois law, you cannot pierce the veil in supplementary proceedings. Illinois says you have to file another case. We did, I believe, both defendant and plaintiffs were in agreement on that during argument in the initial appeal. The law in Illinois appears to be quite convincingly and stated multiple times by this court that you cannot pierce the veil in supplementary proceedings. You have to file a second case. But that order's neither here nor there. Now, in addition, piercing the veil obviously has a higher standard of bar. It requires discovery. You have to meet, various factors, some of which could be difficult to meet depending on the facts. Here, it's a lot more efficient and easier for plaintiffs, at least, since Mr. Carrier personally committed the fraud, to just find him liable for fraud and not go through the complicated veil-piercing process. So that's why we're seeking to add him to the claim and find him liable for fraud. The second way I believe the district court abused its discretion in deciding the first motion for leave to amend is it did not consider the claims independently as to whether new discovery actually was required. It just said, well, there's new discovery required, so I'm going to deny it. And defendant points to that and says, well, plaintiffs should have filed separate motions. According to defendant, I guess we should have filed one motion against DeApril, one motion against Eric Carrier for fraud, one motion against Eric Carrier for veil piercing, and then presumably the defendant would have agreed that whether discovery was required should have been analyzed independently, because there was no discovery required for the fraud claim. All of that discovery had already taken place. To the extent defendant chose not to, it was on notice of it. It should have, the district court should have analyzed whether adding the fraud claim by itself would have required additional discovery. I think it's an abuse of discretion, this throw the baby out with the bathwater approach, where you say, you know, well, one of 3 proposed claims requires new discovery, so I'm just going to deny them all. I don't believe that's the way that those motions should have been analyzed, and I think that was an abuse of discretion. I also think it was an abuse of discretion for the post-judgment motion for leave to amend as well, because we followed the procedure that was set out in Nelson versus Adams. We requested Rule 59 relief to the extent that was required in the very first sentence of the motion. There's no prejudice that could accrue to defendant at this point. And most critically, the Seventh Circuit and the Supreme Court have repeatedly held that claim preclusion has a mutuality requirement. Seventh Circuit, 2010, 2020 Burton v. Ghosh. If a party could not have been bound itself, the mutuality forbids that party from invoking claim preclusion. Mr. Carrier invoked claim preclusion in the second case. He should be bound in this case.
All right, thank you very much. Mr. Novak.
2 points on emotional distress. Number one, we did not object to the standard being put in the emotional distress instruction. The only thing we asked not to be in there was the reference to pain and suffering. That was what they wanted in. We said, don't put pain and suffering in. The next thing we know, there's an instruction that has nothing but emotional distress.
Well, you saw that before the judge read it, didn't you? I mean, it wasn't like you were sitting at the table and she was instructing the jury and you were surprised.
But, Your Honor, we argued there should be no instruction at all on emotional distress.
I know, and you lost that. And then the judge said, well, let me tell the jury what this means, and you said no. And so the jury's sitting in the box and have no idea what to do with it.
I don't believe that happened.
Okay, well, how do you think it happened?
Trial counsel just said, don't put in there words like pain and suffering. That was what was being argued about, not the standard. And and I would say,
well, then did the trial counsel submit a proposed instruction on the standard on what? I mean, it's very weird to have a jury instructed on emotional distress with nothing else. They have no idea when they get back into the jury room what that means.
Judge, neither side proposed that instruction.
Well, if I was the plaintiff, I probably wouldn't want it.
Well,
didn't they work out for their favor?
If you're asking who invited error, 3 parties invited error here, I guess.
And
the judge,
but the plaintiffs won at trial. So it's your problem, not theirs.
Without evidence. Without evidence, it meets the standard. And that standard does apply to all cases. And we cited in the brief the Doe case. And the Doe case applied that standard to counts for fraud and consumer fraud, the severity standard. Judge Chang in the Northern District applied it in a case that had both fraud and consumer fraud.
But was any of this argued in the district court during the instructions conference? Was this argument made during the instructions conference? As I understand it, the only objection that was made is that you didn't want the emotional distress line item at all. That emotional distress damages should not be available at all. Not what the standard should be.
Well, Judge, if this isn't plain error, I don't find anything that was argued. I have, looking in hindsight.
Right. All these instructional error claims have been forfeited, certainly, and perhaps waived.
I don't think so. This is plain error. An error that allows a $225,000 emotional distress when there's no evidence.
No, that goes to substantial rights. The first question is whether the error is plain and obvious. In other words, whether the judge had a sua sponte obligation to overrule the party's arguments and noticed the problem
Well, I
and
think-
corrected herself. That's
I'm
the
hearing
first
from
threshold.
3 judges that that was what should have been done. It was plain, it was obvious. How can you possibly give
Which
an
judges are you
instruction?
talking about?
Well, I'm sorry, I don't mean to put words in or meaning, but I've heard, how could we not object to that? Well, how could the judge not see that it was an error? She should have seen it. It was plain error. Can I-
Oh, my goodness.
Instructional errors are almost never qualify for plain error review. That standard is extremely
Judge.
steep, and it has to be so obvious that no reasonable judge would have failed to correct it.
Judge, we asked for a motion in limine. It was overruled to keep those references to fruit cups out of this case. That tainted the entire case. It's a different issue, but I'm saying
Different issue.
that requires a new trial. The only defense is that it went to punitive damages. The judge barred punitive damages.
But then the judge said I can instruct the jury and give them a limiting instruction, and your client's lawyer said no.
That did not happen. I'm sorry, Your Honor, that did not happen. That instruction happened while punitive damages was still in the case. They offered an instruction that basically said, you heard about fruit cups, it goes to punitive damages. That's not a limiting instruction. That's the opposite. That's telling the jury, take that fruit cup and move it over to punitive damages. Of course, that was objected to. There was no limiting instruction offered after, in the closing argument, after the judge barred punitive damages and the plaintiff said the only relevance was punitive damages, says to the jury in closing argument, they made this homophobic statement. That prejudiced us. That tainted the entire verdict. How could it not? How could it not in this day and age? There should be, at the very least, a new trial. And I am out of time.
All right, thank you very much. Our thanks to both
Thank you for
counsel. The
listening.
case is taken under advisement. Our next case this morning is United States versus Hofschultz. Mr. Brindley, good morning. If you would just hold up for 1 second so we can get everybody settled. Okay. Go ahead.
May it please the court, my name is Bo Brindley and I represent the defendant's appellant Robert and Lisa Hofschultz. In Ruan versus United States, the majority found that proving the guilt of a medical practitioner under the Controlled Substances Act, Section 841, requires proof that the practitioner issued a prescription that she knew was outside the scope of her authorization. That is the required mens rea after Ruan. The jury in this case was not given that instruction. That is an omitted element on a contested issue.
How so? I looked at your proposed jury instructions here, and your proposed jury instructions. Judge Rovner, I'm sorry, you were trying to ask a question. Go ahead.
All right, thank you.
You're welcome.
The instruction the court ultimately gave applied the knowing or intentional standard to the outside the usual course and legitimate medical purpose requirement. The court did this by adding the word intentionally to the second element, that the defendant did so by intentionally distributing or dispensing the controlled substance outside the usual course of professional medical practice, not for a legitimate medical purpose. Why isn't that sufficient under Ruan? The Supreme Court held that the same mens rea applicable to the elements should also be applicable to the except as authorized provision. The use of intentionally in that instruction certainly seems to do just that, doesn't it?
Two reasons that's not good enough, Judge. First of all, I don't think it does that, because what intentionally says in that element is that the defendant intentionally distributed, and then it goes on to say without, outside the usual course of professional practice and without a legitimate medical purpose. So intentionally there, the jury could apply that to distribution and not to the professional practice and outside with no legitimate medical purpose. We asked for another element that said that the jury must find that the defendant knew that it was outside the usual course of professional practice and for no legitimate medical purpose. The district court refused that. And throughout the entirety of this discussion with the district court, the problem we had was that the district court insisted that this was a subjective standard and said that explicitly. I'm sorry, an objective standard. I misspoke. District court insists it's objective. Ruan says, no, it's not. It's absolutely subjective. But to follow up on, I think, what's more important, Your Honor.
I think you're misstating the reasoning
Right.
of the district judge in this case. The discussion of an objective standard relates to how the usual course of medical practice is proved and determined by the jury, and the legitimacy of the medical purpose. Those are objective inquiries.
Yes.
Element number 2 of the charge here clearly incorporated the subjective standard of intent that the Supreme Court announced in Ruan. And the instruction did so in advance of Ruan. So Judge Pepper predicted accurately what the outcome in the Supreme Court's case would be. So I really don't follow your argument about what she did wrong.
Well,
And might I just add to that, please, that I thought that the court made clear that although the intent standard for acceptance authorized included a subjective component that allowed for the prescriber's belief that, they were acting in an authorized manner, the government could prove that the defendant intended to distribute outside of that authorization by comparing the defendant's conduct to the objective standard and assessing whether the defendants did subjectively believe that their conduct was authorized by comparing the objective standard for professional conduct against the defendant's conduct and determining their intent by how much their conduct deviated from the objective standard. And I thought that's exactly what the instructions and the expert testimony allowed. So if you could, answer both our queries, that'd be great.
I think the critical problem here is the one that the Kahn 2 court addressed when we presented this exact same argument in Kahn. And what they said is that applying the knowing standard to these prongs of section 1306.04, the regulation, is not sufficient to establish guilt. In Kahn, they specifically said, in talking about Ruan and how Ruan cited Liparata, Kahn says, knowingly acting with no legitimate medical purpose is not sufficient to establish guilt. Knowingly acting outside of professional norms is not sufficient to establish guilt. If Kahn 2 is right, these instructions don't work. They were wrong because the question is about what the defendant believed in terms of the scope of authorization.
No, isn't it legitimate medical practice that you're leaving out here? Because it clearly doctors can act outside the usual course of professional practice. They do that all the time. When you go to a doctor and say I'm having migraines, and the doctor says actually there's this medication for Alzheimer's that works on migraines and I'm going to prescribe you this medication and you're going to take it and it's going to fix your migraine. They do that. The government does not regulate the practice of medicine, right? So doctors do that all the time. They act outside the usual course of professional practice, but they act for a legitimate medical purpose. And that's the problem when you're prescribing opioids to drug dealers. You're not acting within the scope of legitimate medical purpose.
And Judge, the problem here is the word legitimate. And I think that in Con 2, the court explicitly said knowingly prescribing for no legitimate medical purpose is not sufficient to establish guilt, because that is not the standard. Under Liparata and Ruan, which cites Liparata, the question is, did the defendant know that the prescription was legally unauthorized? That's why they're talking about Liparata. Liparata connects to authorization, as did the majority in Ruan. And so Con has to be wrong if it's enough to prove a knowing prescription with no legitimate medical purpose. And the point of it is, and the difficulty is, and what Con was getting at, is that legitimate medical purpose uses that objective term, and it is legitimate according to who? The Supreme Court majority could have applied the knowing mens rea to the language of the regulation. They did not. They were given that chance. It was argued that way. They said no. And they did so by criticizing the very language that we're talking about here and the court used here. The prongs of 1306.04, heavily criticized as vague and not able to readily separate guilty from innocent conduct. The mens rea doesn't apply to that language. It applies to authorization. The jury has to be told.
Was Lisa Hofschultz not allowed to argue to the jury that she subjectively believed that the prescriptions were authorized, or is your claim that the instructions did not allow for the jury to consider her subjective intent?
Certainly she testified that she believed she was authorized. The problem is the jury instructions did not say that her belief about the scope of her authorization was dispositive. Ruan says it is. The district court here said a medical practitioner's own treatment methods do not constitute professional medical practice. According to Ruan, if a prescriber sincerely believes that he has the authorization to write a prescription, regardless of whether that purpose is different than what most other people in the medical community would deem legitimate, that's not a crime. And so according to Ruan, a medical practitioner's own treatment methods, if sincerely believed to be within his authorization, is professional medical practice for deciding whether you have a crime under Section 841. And the Ruan case specifically said that even failing to act in a manner that others in the medical community would view as medical care at all is insufficient. If that is insufficient, then so too is it insufficient to prove that someone knowingly acted for a purpose that his colleagues in the medical community might not find legitimate. The problem with the language that was criticized in Moore, that is criticized in Ruan, and that Ruan attempts to put a stop to, is that these words, usual course, and this word legitimate according to who? Usual according to who? It's not clear enough. What is clear, as the court said, is what did the defendant think about the scope of authorization? Did she believe she was legally authorized to write the prescription, or did she not? And in Con 2, they said that's all that counts. Con said that this very same instruction, and I would argue that the Con instructions were more favorable, was not good enough and required reversal of all of Dr. Con's convictions when we presented the exact same argument to the 10th Circuit, and the government presented the exact same argument to the 10th Circuit that the government presents here. The 10th Circuit agreed with us completely. And the 10th Circuit is correct.
I'd like to ask you a quick question about
Yes.
Mr. Hofschultz.
Yes,
Because he asserts on appeal that he had no medical training.
right.
It appears he had no difficulty offering medical opinions to the staff. He told Nurse Kalski, for instance, that handing out pre-written prescriptions was fine and kosher. Why wouldn't that right there be enough to show a conspiracy with Lisa?
Well, he may have thought that that was okay, but he relied on Nurse Kowski to do it, and Nurse Kowski said that based on all of her experience, she thought it was okay too. The problem with Mr. Hofschultz is that he lacked medical training, and more importantly, he didn't have specific information about the stability of these patients that the government contends is the reason why it was improper to give these prescriptions in the way that they were given. But ultimately, I think the important issue here is that the one that was addressed in Con 2, the government tries to say Con 2 says what it does not. And the fact that the Supreme Court decided this case by likening it directly to Liparata. Liparata says you have to have knowledge that you're legally not authorized. The Supreme Court said that's what we're doing here too.
That's actually not what the Supreme Court said.
Well, the Supreme Court cites that case and says just as there, here, the critical element is authorization.
The last part of the court's opinion specifically authorizes the objective inquiry into the medical authorization question.
They say you can prove it with circumstantial evidence, which is what Kahn says. These prongs can be objective evidence of whether or not someone's is sincere in saying they believe they were authorized. But it is not sufficient to establish guilt. To say that the district court here was correct is to say that the 10th Circuit is wrong. And we believe that would be an error that would create a circuit split that is unnecessary given the citation of Liparata by the Supreme Court and given the position that was taken by the court in Con 2. And so with that, I would reserve the remainder of my time for rebuttal.
Thank you. Ms. Tableson.
May it please the court, Rebecca Tableson on behalf of the United States. Section 841 carries what the Supreme Court described as ordinary scienter requirements, knowledge or intent. Ruan held that in the prosecution of a medical provider, those ordinary scienter requirements apply to authorization to write a prescription. So the defendant must know she is prescribing in an unauthorized way or intend to do so. The question where I think we join issue here is, what does unauthorized mean? The simplest and most obvious place to look is to what Ruan described as, quote, the regulatory language defining an authorized prescription. That's legitimate medical purpose in the usual course of professional practice. Now, the regulatory language from section 1306.04 is not plucked from thin air. The opposite, as the Supreme Court has explained, it is a, quote, parroting regulation that, quote, does little more than restate the terms of the statute itself. That's Gonzalez against Oregon at 257, where the court traced the language of the regulation back to the CSA itself. So, for example, the phrase that Mr. Brindley complains about, legitimate medical purpose, that's right in 21 U.S.C. 829E2A and 21 U.S.C. 830B3A2. These are statutory terms, same with usual course of professional practice. So under Ruan and the CSA itself, a medical provider can be convicted if she knowingly or intentionally distributes drugs without a legitimate medical purpose or outside the usual course of professional practice. That, with a substantial defendant-friendly tweak, is precisely how the jury was instructed in this case, following the long-standing precedents of this court, and that is how the courts of appeal have been interpreting and applying Ruan.
Ms. Tableson,
Yes.
in the instruction for controlled substances illegal distribution, that's page 30 of the instructions. The district court gave us the second element that the jury must find that the defendant did so by intentionally distributing outside the usual course, etc. The instruction does not require that she did so knowingly. Would that be problematic?
Well, that is the one defendant-friendly tweak that I was referencing. The correct thing to say is knowingly or intentionally, but intentionally
Right.
is a higher scienter standard than knowingly. So it would have been to our benefit to say knowingly or intentionally. We're obviously not raising that here. We're fine with it. But that, I think technically the very correct thing to do would be to say knowingly or intentionally.
Okay.
I want to address Con 2, which, contrary to my friend's assertion, does not endorse their willfulness standard. But there are two confusing sentences in Con 2 that I want to front with the court. The core problem that Con 2 identified is, under prior circuit precedent in the 10th Circuit, the jury could convict if Dr. Khan had either subjectively prescribed without a legitimate medical purpose or prescribed outside the objective course of professional practice. So that dichotomy with one purely objective element is obviously a no-go after Ruan, but that is not an issue in the Seventh Circuit or in this case. The second problem with the jury instructions in Con 2 was that they had a good faith instruction that Ruan had criticized. Again, not a problem in this case. So the holding of Con 2 does not point to any error in the district court's instruction here. That being said, there are two confusing, in my view, sentences of reasoning on page 1316 of Con 2, saying that under Ruan, the criteria in section 1306.04 are not distinct bases to support a conviction, but are references to objective criteria that may serve as circumstantial evidence of a defendant's subjective intent. I confess I am not sure what that means, nor how to apply it in practice. If the criteria in section 1306.04 do not define what an authorized prescription is, then it's not clear what else would define it. Con 2 doesn't say. Con 2 also seems unaware that section 1306.4, that language, is just a parroting regulation that summarizes the statutory text. So that's the trick with Con 2. I'm not sure what to do with those sentences, but every other circuit to consider these issues post-Ruan has concluded that the question is knowing or intent applied to legitimate medical purpose and in the course of professional practice. The Hofschultzes disagree. They think that unauthorized refers to the criminal prohibition in section 841 itself, which has the effect of transforming this into a willfulness crime. That is a very far cry from the ordinary scienter requirements that the Supreme Court described in Ruan. Alternatively, or maybe in addition, I think the Hofschultzes argue in their brief that unauthorized might refer to the standards for criminal liability under the Harrison Narcotics Act of 1914, which is no longer in effect. The CSA expanded upon, and in any event, as the Supreme Court described in Moore, the Harrison Narcotics Act permitted conviction of, quote, physicians who departed from the usual course of medical practice. So that does not help. As a third alternative, and I think this really might be the heart of it, the Hofschultzes argue that the only real measure of authorization is the provider's own purely subjective view of what is appropriate. The provider's own personal prescription practices define the legitimate course of medicine, right? And you can see this in their jury instructions argument and also in their objection to Dr. King's testimony about what is objectively the legitimate practice of medicine. That is a radical idea that has no basis in the text of Section 841 or any case law, and the Supreme Court waved it off in Ruan. The Solicitor General had argued, oh, there's a risk we'll get to this purely subjective place, and the Supreme Court said, no, there's not. We're going to do this the normal way. You'll compare the conduct to the objective standards and see if you can prove the mens rea. I want to note also, as Judge Rovner mentioned, that notwithstanding these legal disputes, the Hofschultzes were able to and did make their mens rea arguments to the jury. Lisa Hofschultz testified at length that she was only trying to help her patients. That was perjury, as the district court found, and the jury rejected it. The Hofschultzes put their own expert on to talk about their own version of the practice of medicine. Again, their jury rejected that testimony. Mr. Brindley's entire closing argument was about mens rea, arguing without objection that his client's purpose was to treat pain and that the jury must acquit if they believe that. But the jury convicted on all counts after being correctly instructed, and that was the correct outcome legally and factually.
Now, in theory, I do have a question. In theory, the defendants could have given 90-day prescriptions or allowed 90 days between visits for these prescriptions. So, what
I found
in
this on the web.
particular
The defendants
makes
could have given 90-day prescriptions
Good
or allowed
Lord.
90 days off between visits for these prescriptions. Check it out.
I think
I didn't
Siri
know.
is
I hear you, Judge Rovner. I'm sorry. Continue.
I'm so sorry. Siri is my law clerk. What in particular makes the prescriptions issued in Lisa's absence, but on Lisa's authority outside the usual practice? I mean, if she legitimately gave out the original prescriptions, could she have given 2 months more without further evaluation, or is it because she never properly assessed or monitored these patients? Or is it because she didn't do so on these particular occasions when she was out of the office?
It's a mix, Judge Rovner. So Dr. King testified about this at trial, as did multiple nurse practitioners who strenuously objected to this practice and told Mr. Hofschultz about it. What happened here is that Ms. Hofschultz left the clinic, and they, after multiple nurse practitioners refused to hand out pre-written prescriptions in her absence, Mr. Hofschultz hired a registered nurse, which I've now learned is a sort of lesser trained nurse who cannot hand out prescriptions, who handed out over 550 prescriptions in the absence of a medical practitioner examining these patients and determining these prescriptions were appropriate. And Dr. King explained that the files that, he examined some of the files of these patients who received these pre-written prescriptions and explained that those patients were not appropriate for the pre-written, 90-day supply because they were not stable. And also, in addition, they had never been properly examined. There was no evidence in their files that medicine had ever been practiced. There was no, diagnosis, no treatment plan, no follow-up on whether medicines were working. So I think it's a mix of a lot of the things you mentioned. I can briefly address the other two claims here, just to give the court a chance to ask any questions. Dr. King's testimony, as all parties agreed below, this is squarely on all fours with Coley. Nothing about Ruan undermined Coley. Rule 704 and Coley confirm there's no error here. And finally, as to sufficiency of the evidence. This was not a closed case. Ms. Hofschultz was the #1 Medicaid prescriber in Wisconsin of oxycodone, methadone, and OxyContin in 2015. That's compared to cancer practitioners, palliative care doctors in major hospitals. She outdid them all from her clinic in Wauwatosa.
It's my understanding that the clinic itself was basically a storefront kind of a clinic. There wasn't much in the way of medical apparatus.
She practiced in two places, Judge. At the beginning, she practiced in a sort of a single room in a chiropractic clinic that she rented by bartering opioid prescriptions from its owners. And that was just a one-room operation. Then they moved to the Mayfair Mall, where they had a sort of a suite. I'm looking at the trial attorney. Multiple rooms. One room with a table. Sorry, Judge. I just want to make sure I got you exactly the right answer. I've never seen it myself. But yes, it was not a facility that was set up to properly examine and diagnose people. And in fact, they did not do that. They charged $200 to $300 cash per visit. They didn't take Medicaid from the substantial number of patients who had it. They distributed over 2 million opioid pills into Wisconsin during the conspiracy period. Patients traveled from hours away to pay their cash and to get these drugs. Some patients got their prescriptions without ever having to set foot inside the clinic at all. Patient DT, for example, paid extra cash when she came to take home prescriptions for 2 others, RZ, her mentally disabled son, and another friend who the Hofschaltzes would not permit to physically enter the clinic because, quote, he had an odor. Lisa Hofschaltz told DT to put these prescriptions in her bra as she left the clinic. At least one patient, Frank Erbel, died, overdosing on pills supplied by the Hofschaltzes. I could go on at some length, but I won't. I'm happy to answer any questions. If there are none further, we respectfully ask that you affirm the judgment below.
Thank you. Mr. Brindley.
I think some of the confusion here stems from the fact that whether a prescription is unauthorized is an objective question. Whether it's unauthorized is objective. But what Ruan says is the mens rea is a subjective question about what the defendant believes about the scope of authorization. This jury did not get any instruction that said, or let them believe, that the defendant's subjective belief about the scope of her authorization was sufficient. And the government says that it's a radical position to suggest that what Ruan means, as well, I think Kahn clearly says, what Kahn 2 is saying that they say they don't understand is these criteria from 1306, they're the objective evidence about whether a prescription is authorized or not. The mens rea question then is whether or not the defendant believed subjectively that she had the authority to do that. They criticize that as a willfulness standard that's radical, but I point this out. The standard that it's in our brief, the standard the government suggests is close to the standard that the concurrence suggested. And what Justice Alito criticized was not applying a standard based just on good faith medical purpose, but taking a radical new course. That radical new course is the same standard that was announced in Liparata and applied here. And what that means is that a defendant, to be guilty, must know and believe that her conduct is outside the scope of her legal authorization. This jury received no instruction on that makes it an omitted element that requires reversal because it was a contested issue, and pursuant to Netter, when you have an omitted element in a contested issue case, reversal is necessary here for the exact same reasons it was in Kahn.
Actually, that's not what Nader says, but we know what Nader says.
Netter says
That
you have to
omitted
have...
elements are subject to harmless error review.
They are in cases where the evidence is uncontested and overwhelming. That's what Netter says explicitly.
But that's
and
whether
this
the
was
standard is met, not whether the standard applies. Two separate questions.
Sure, but under the Netter standard here, this was a contested issue. If we have an omitted element under Netter, as to mens rea certainly, and it's a contested issue, as it was, then overwhelming evidence doesn't matter. That position was also the same one discussed and announced in Kahn 2. Thank you.
Thank you very much. Our thanks to all counsel. The case is taken under advisement, and we will take a brief 10-minute recess before calling the third case this morning.
is? Yeah. All right, we'll have to tell him. Did you say something? Oh. I'll say something.
versus Western Illinois Correctional Institution. Ms. Walters.
Good morning, Your Honors. Second, please. This Velcro's not really taking. May it please the court, my name is Kelly Walters. I represent Latrona Moore, who is the widow of the formerly incarcerated and now deceased former plaintiff, Lamont Moore. Today we're asking the court to overturn the district court's decision to grant the defendant's motion for summary judgment. In this case, the district court came to the mistaken conclusion that a reasonable jury could not find that defendant Correctional Officer Gatewood was sufficiently on notice about a violent altercation that would take place between Lamont Moore and Khalil Sample, the two inmates. In fact, after his fifth warning, each of which followed an incident with Sample, Mr. Moore was attacked by Sample. Sample punched Mr. Moore with a key protruding through his fingers. The key entered Mr. Moore's eye socket and ripped it out of his head. Today, the primary issue plaintiff poses is that the district court improperly made conclusions about disputed material facts and then turned around and applied those conclusions to an inappropriate standard for deliberate indifference. The parties have provided two very different accounts of what occurred. I'm sorry?
I don't know.
Sorry. The parties have provided two very different accounts of what occurred. Mr. Moore has consistently stated in his testimony, in his grievances, and through his affidavits that he has warned Gatewood 5 times and expressed concern for his own safety, requesting to be moved across the room. Gatewood has testified that Moore never gave him any of the warnings. The parties have also differed on the severity of Mr. Moore's injury. Mr. Moore has testified that he cannot walk without the assistance of his wife or his sister. He cannot drive without special glasses, and that he has fallen 15 times after losing his balance. For having
Now, excuse me, Ms. Walters, at his deposition, Mr. Moore said that he did not fear Sample, did not expect Sample to hit him, and that Sample said nothing to him to make him think that Sample was going to hit him. He literally said, I didn't see it coming. If Moore did not see it coming, how do you think Officer Gatewood would have seen it coming?
Well, that comes down to the specificity of the warning that Mr. Moore gave to Gatewood. And it also comes down to reading the deposition fully within context. It's not surprising that Mr. Moore stated that he was not afraid of Mr. Sample. Mr. Moore is a man who's been institutionalized for the majority of his life and is not about to admit, as a 5'11" man, that he was scared of a man who was about 5'5" or 5'6". Additionally, when reading the deposition in its entirety, Mr. Moore stated that he didn't know Sample was going to hit him. But if we read the transcript, we find that the plaintiff didn't know that Sample's attack would actually be quite so vicious. He knew an attack or a violent altercation was coming. In fact, a full reading of that deposition transcript shows that Sample didn't even realize how vicious his attack would be. Mr. Moore turned his head, and that is why the key went into his eye. He did not intend to do that.
Can you point to any specific statements that Moore made to Officer Gatewood that would indicate that he feared an attack by Sample? And we've got to set aside the affidavits and grievances and focus on Moore's own words in his sworn deposition. Because he consistently testified that he told Officer Gatewood that Sample was horsing around, splashing water, making noise, tussling around, mouthing off. But I'm wondering where he testified that he conveyed any threats or described any physical confrontations to the officer.
Well, I would analogize this, Your Honor, to the Kersey case that came down after we briefed the case, July of 2023. Much like that case, the inmate in that case sued the correctional officer for failure to protect him from his cellmate. The district court granted the summary judgment, stating no reasonable juror could find that the defendant disregarded the risk But like the unstated behavior, the nonverbal communication of plaintiff's cellmate and Kersey, a jury here could find that Khalil Sample's acts, specifically the splashing of the water, the trying to break into plaintiff's property box, causing a ruckus, making ongoing comments, were sufficient to put the defendant on notice of a threat.
Well, that's would be a very high threshold, seems to me, because, we're in a prison.
Agreed. We are in a prison, and while we can't make prisons safe, we can prevent danger that has come to our knowledge beforehand.
It's my understanding that the complaints that your client was making, or your client's son was making, not your client's, that Lamont was making,
Yes.
let's put it that way, to distinguish
you've read a lot of
Lamont, the original plaintiff, from his mother, who's now litigating. He was complaining to Gatewood about general problems with younger inmates in his vicinity in this large bunk room. As I understand it, it's a large open bunk room. These are not private cells. So there's not notice to Gatewood that this specific inmate, Sample, the ultimate assailant who committed this horrific attack, was threatening violence. It's sort of horseplay argument, or horseplay complaints, and a request to be moved to the other side of the bunk room. And I don't think the evidence shows anything more specific than that.
Well, I would disagree. The standard requires factual inferences. And you'll find that if you look at the timeline, it was after an incident with Sample on June 11th, 2015, that he first contacted Gatewood about his issues with Sample. And then he had an issue with Sample again on the 14th. There were no issues on the 12th and the 13th that we're aware of. One issue came on the 14th. After that, Mr. Moore went to Gatewood. Then he had another issue with Sample and his friends, whomever they might be, where Mr. Moore went to Gatewood again.
But what does the evidence show he complained of? Are they? My understanding is that they're all in sort of, they're generalized complaints, not specific complaints about Sample and concern about violence from Sample.
Well, generally speaking, I mean, what I would say that Mr. Moore complained of is he gave Mr. Gatewood the who, the when, the why, and the where. The only thing he didn't give him was the how.
What specifically did he say? What does
Well,
the evidence show?
Truth be known, in his deposition, he did not give a quotable statement.
That's the problem.
Yes.
We don't have any solid evidence from which a jury could conclude that Gatewood was on notice that Sample was a violent threat to Lamont, and that these complaints were all of a highly generalized nature about other inmates in the vicinity of his bunk.
Well, once again, I would respectfully disagree. I don't believe, and I believe there is precedent here, that specificity is not the end-all be-all for a failure to protect claim or a deliberate indifference standard. Additionally speaking, I think that the fact that it is an inference-based standard, and the fact that these particular complaints to Officer Gatewood came every time after he had an incident.
But we don't know what their content was. That's the problem. So there's nothing from which a jury could infer that Officer Gatewood was on notice.
But we actually do know what the content was, were we to look at the grievances that Mr. Moore put in.
Well, that's not what he testified to. He didn't testify to anything specific regarding Sample, his concerns about Sample, or even the other inmates.
I respectfully disagree. While he did not provide a verbatim statement of what he had said on June 14th, 2015.
Well, what did he say generally?
He generally
told
said
Officer Gatewood.
He generally said that these young guys, Sample, well, first of all, he complained to him about Sample about the incident in the bathroom, right?
That's splashing water.
Yes, that's the splashing water. It's
That's-
certainly
that's not enough.
It's not the crux of this by any means, yes. But then you go on to June 14th, where you have Mr. Sample trying to break into Mr. Moore's property box. And he goes to Gatewood and tells him about that. Then you have Mr. Sample tussling with his friends, specifically around Mr. Moore. And Mr. Moore goes to Gatewood and tells him about that, each time asking to be moved. Mr. Gatewood, Officer Gatewood, was well aware of the fact that there was a potential for violence here. Officer Gatewood, in his deposition even stated that it is his responsibility that if an inmate comes to him indicating he has some concern for his own safety, he has to move him. Officer Gatewood additionally even went to the lieutenant to see if he could move them, if Mr. Moore's deposition is to be believed, and which it is at this point.
You can continue.
Oh, okay. Well, not to belabor it, but the district court and the defendants have manipulated the standard for failure to protect in this case, and much like the Horschel versus Casper case, have failed to recognize that jailhouse threats are rarely made with the level of detail that the district court is demanding. However, Moore provided Gatewood with the, as I said, the who, the where, the why, and the when, and I'd like to point out that most of the cases in the Seventh Circuit that have found no liability on a failure to protect claim have been because the plaintiff was not able to indicate the exact person. And here, Mr. Moore did so. The only thing Mr. Moore didn't do was reach into a crystal ball and reveal the how of the attack. He was not able to tell Gatewood the viciousness of the attack. I see I'm at 3 minutes. I'm going to reserve.
Thank you. Ms. Hanson.
Good morning, may it please the court. Christina Hansen on behalf of defendants appellees. Defendants were entitled to summary judgment on both the Eighth Amendment claim against Gatewood and the ADA claim against the Department in Western Illinois Correctional Center. First, as to the Eighth Amendment claim, Moore failed to come forward with competent evidence from which a reasonable jury could conclude that Gatewood was deliberately indifferent to a serious risk to Moore's safety. To meet his burden at summary judgment, Moore had to present sufficient evidence for a reasonable jury to find that he knew of a serious, imminent risk of harm and that he failed to take any reasonable steps to abate that risk. And the summary judgment record falls far short of that standard. Moore asked Gatewood to be moved on several occasions, and he complained about young guys near his bunk horseplaying or messing around. But the competent evidence in this case, which is Moore's own testimony, as well as the Brownlee affidavit, presented no evidence that Gatewood was on notice of an actual risk of harm. The couple days before the incident, Moore testified that a couple days before the incident, he asked to be moved to a different area. As plaintiff's counsel pointed out, it was an open dormitory. He didn't ask to be moved into protective custody. He didn't ask to be moved into a different dormitory. He asked to be moved within the same J unit that he was in. And he complained that the young guys were making noise. He couldn't get any sleep. So that was Mr. Moore's testimony. Specifically, he said, he told the officer, "Would you move me to the other side of the unit so I could stay away from him? There was a bunch of young guys in the area I was in." He testified, "You basically couldn't get sleep on that side. There were a few of us older guys that were up in the unit." Those are not the kind of reports of a specific, imminent, plausible threat to somebody's safety that would put a correctional officer on notice of a serious risk to his safety. As to the day of the incident, Moore again testified that he complained about the young guys horsing around, and he asked to be moved. but he did not report a specific threat to his safety. In fact, his own testimony regarding his interactions with Sample, he didn't recall being threatened by Sample. He testified to 2 occasions, one a few days before the incident, where he said that Sample said something to him. They exchanged words, but he didn't remember what Sample said, and he testified that it was something that he, quote, brushed off or walked off. So he didn't recall a specific threat that Sample had made. And also on the morning of the incident, he testified in the same way, that Sample said something to him, but he didn't recall being threatened by Sample, and he brushed it off. So although he went to talk to Gatewood, he didn't perceive a threat. His own testimony was that he didn't perceive a threat, and so there wasn't a threat to report. Indeed, on the day of the incident, his testimony was that he didn't see it coming. He didn't expect Sample to hit him. He said, when asked if there might have been anything that alerted him to whether he would be attacked, he responded, no. If he did, this wouldn't have happened. I did not see it coming.
May I ask you something about the ADA claim, please?
Yes.
Would you address Mr. Moore's repeated falls? It appears that his monocular condition put him off balance, causing, to bump into things, fall repeatedly. Why wouldn't that create a genuine issue on whether he was substantially impaired in walking? I understand that he didn't fall while he was at Western Illinois, but why would that be determinative if he fell repeatedly later after his release?
Well, the ADA claim is against the department and Western Illinois Correctional Center relating to the 10-month period between August 2015 and May 2016 when he was incarcerated at Western. And his own testimony there was that he did not experience any falls there. And so the testimony later, with respect to his issues with balance and the fact that he had experienced falls, happened later when he was outside of the department's custody. And so that testimony wouldn't be relevant to whether he was in need of an accommodation at Western Illinois Correctional Center. The Supreme Court has recognized that monocular vision is not a per se disability, that a plaintiff has to present evidence that he was substantially limited, that a physical impairment substantially limited one of his major life activities. We don't dispute that the monocular vision was a substantial impairment. The issue is whether the difficulty that he presented rose to the level of a disability.
Why do we have to decide that in this case?
Why do we have to decide whether? Well, there are other bases on which to affirm summary judgment in this case. To begin, this is as I mentioned, this claim is for the 10-month period that he was incarcerated at Western, and so the only relief available to plaintiff at this stage would be money damages, which are unavailable under the 11th Amendment because there's no constitutional dimension to his claim, and so the court need not address the merits of the ADA claim. But if the court does address the merits, as the district court found, Mr. Moore did not have a disability under the Americans with Disabilities Act, but also he didn't go through the proper channels of requesting the accommodation that he sought, which was to have his housing assignment moved. As plaintiff acknowledged, he was given a slow walk permit.
So there was no deliberate indifference. They acted.
That's correct. There was no deliberate indifference, which is necessary to show intentional discrimination to allow a claim for money damages under the ADA. And so the court may affirm on that basis as well. So if there are no other questions, we would ask that the court affirm summary judgment on both the 8th Amendment claim and the Americans with Disabilities Act claim.
The sovereign immunity issue, the 11th Amendment issue, wasn't litigated at summary judgment. It was preserved in your answer, but not litigated, is that right?
That's correct. It wasn't litigated at the summary judgment stage. And so, but this court may excuse the forfeiture, given that it's a, that it's an issue that goes to comedy, and also to, whether the court should hear the case.
But it's not jurisdictional. So we don't have to address it.
You don't have to address it.
Thanks.
Thank you.
That's all. Thank you. Ms. Walters.
Thank you. To address some of the claims made by my respected opposing counsel, very much disagree that the record falls short of the standard for an inference for deliberate indifference. Would I like to see more? Yes. But at this stage, a reasonable juror could see 5 different warnings in the same day, after each one after one separate incident with the same gentleman, as being an inference that there is a real safety issue there. And the one thing everybody disagrees, I'm sorry, excuse me, the one thing everybody agrees on in this case is that Mr. Gatewood, Officer Gatewood, did nothing after getting all 5 of those warnings. And the fact that opposing counsel raises the issue that Mr. Moore wanted to move across the room, he wanted to move across the room from his friends. He asked for a really reasonable remedy in this case. And once again, Officer Gatewood, despite having 5 warnings that day, did absolutely nothing. And I believe at this point a reasonable jury could easily find that this was deliberate indifference. There are factual inferences Officer Gatewood knew, and a reasonable jury could easily find that. Also, I'm sorry. Also, opposing counsel indicated that Mr. Moore brushed off the statements from Mr. Sample. And yes, he did indicate that he did. He didn't indicate that they were terribly threatening. He didn't remember what they were also. But if he wasn't concerned from those statements, once again, why would he have gone to Officer Gatewood? Why would Officer Gatewood have gone to the lieutenant?
Well, and a jury could filter those brush-off statements that he made in his deposition by attributing it to the kind of prison culture that exists.
Yes.
Inmates don't want to acknowledge that sort of thing.
And likewise, the jury
afraid.
Could assume that this is the reason why. Yes. Mm-hmm. So we respectfully request that this court find that a jury must hear the facts of this case, because there are so many in dispute, and overturn the grant of summary judgment.
Thank you.
Thank you.
Our thanks to all counsel. The case is taken under advisement. We'll move to our next case this morning, Jones versus Anderson.
Hello, Your Honors, and may it please the Court. The District Court in Mr. Jones's case erred and should be reversed for 2 primary reasons. First, the Court erred in failing to appoint Mr. Jones' counsel. The District Court did not conduct the required particularized assessment into whether Mr. Jones was able to adequately litigate his case without assistance, and whether his case was particularly complex. Second, while the District Court does not need to reach the merits of the case, the District Court also erred in granting summary judgment in favor of defendants on all 3 of Mr. Jones's claims. As to Mr. Jones's request for assistance of counsel, the District Court was required to conduct a particularized assessment of both the difficulty of Mr. Jones's case as well as his ability to litigate it. The District Court did not do this, instead issuing a boilerplate decision simply concluding that Mr. Jones's claims were not complex and that his pleadings demonstrated that he was able to adequately litigate this case himself. The district court's opinion failed to address several of the factors raised in Mr. Jones's request for counsel and subsequent follow-up requests to the court over the 4 months in between. First, the district court did not consider the stage of Mr. Jones's case when it ruled on his request for counsel. As this court has held in James and McCaw, a district court abuses its discretion when they fail to consider the complexities of advanced stage litigation activities and whether a litigant is able to efficiently handle them. Jones alerted the district court to the difficulty he was having in obtaining discovery, including getting video evidence and obtaining his medical records. Yet the district court did not even advance to the stage of the litigation that the case was in. As this court held in McCaw, a district court abuses its discretion when it fails to specifically address whether a plaintiff is able to identify, collect, and present the right types of evidence for his claims. Instead, the district court simply concluded that his filings demonstrated that he could represent himself.
How was he prejudiced here? How was Mr. Jones prejudiced? If the district court did err in failing to conduct a thorough analysis here as to whether counsel was warranted, what was the prejudice?
Sure. So Mr. Jones was prejudiced in several instances. First, if you look at the district court's opinion in summary judgment, it rejected several of Mr. Jones's claims because they said that he did not submit a verified complaint or declaration. And in fact, he did submit, his second amended complaint was verified. And had Mr. Jones had the assistance of counsel, that his counsel either would have pointed the district court to that verified complaint or helped him submit a declaration. He also was not able to gather any evidence to support his claims.
Well, he has the video. You know, I wonder what effect the video has here on any prejudice claims, because the only thing that we don't have on the video is his being handcuffed, right? But the video starts right after his handcuffing. And of course, the video appears at least to be inconsistent with his statements regarding broken bones and things like that as a result of the handcuffing. That doesn't really bear itself out as he's put in the chair and wheeled and strip searched, and then he goes and sees the nurse and he complains of bruising on his wrists, and she looks at him and says there's no bruising.
Sure. So the video, we do have video evidence of what happened, as you stated, after he was handcuffed and right before he was put in the restraining chair. However, there is no video evidence of what happened before that. And part of the factors in determining on summary judgment, in this case, whether he had an Eighth Amendment claim, includes the disruption that Mr. Jones was causing, whether there was any attempt for the defendants to minimize the use for the need of force, and there's no evidence of what happened before that.
None of that matters if the video conclusively shows that there was no force used, and the video conclusively shows that there was no force used.
So the video might conclusively show that there was no force used after the amount of handcuffs, although we would disagree with that, given that he had a documented medical history showing that he shouldn't be handcuffed behind his back, that he had shoulder issues, that he couldn't stand. So we would disagree that putting him in handcuffs behind his back, forcing him into a restraint chair, putting him in legs restraints, forcing him to go to undergo a strip search, and then putting him in the RHU unit, a jury could reasonably find that that was excessive, given that he posed no physical threat. He simply responded to the defendant's allegations or statements that he needed to go to a cell that he could not access because it had stairs. Mr. Jones's verified complaint states that all he did was say, I can't go to that cell because it has stairs. I have a medical restriction that you need to look at. To confirm that, the defendants in fact did look at that, did confirm that he had a medical restriction that made it so that he couldn't use stairs, but said, well, that's too bad. And then there was some sort of altercation that resulted in him being handcuffed. But we don't have video evidence of what happened leading up to him being handcuffed.
But how could a lawyer have helped him at that point? You know, we don't have video evidence. He said what happened, and at least what he said happened is inconsistent with what you see on the video once the video starts. But what could a lawyer have done for him?
Sure, a lawyer could have done several things. The lawyer could have taken the depositions of some of the defendants, particularly Mr. Anderson, to figure out what happened. They could have taken statements from other.
Let me ask you one other question on that in the depositions. What do we do with the? You know, he asked for a lawyer very early in the proceedings, and the district judge says no. is he never asks again. He never goes to the judge and says, okay, now we're in the discovery stage and I can't obtain medical evidence, or I'm unable to obtain depositions. I can't do depositions. What do we do? What do we do with that? The fact that he never asked to get again.
Sure. So he requested counsel right after the initial pleadings were filed. The district court then sat on that request and didn't rule on it until 4 months later. And to go to your question, in this court's concurrence in Pruitt, they specifically stated that once a pro se litigant, in particular one that is incarcerated with no access to the law library and will not understand what the term with or without prejudice will mean, might understandably think that once their motion for recruitment of counsel is denied, that they would be annoying the judge, or that they're not allowed to resume that motion or file a renewed request. So at the very least, what the district court judge could have done was put the decision in layman's terms and said something like, if you believe later on in the case that you do require assistance of counsel, you can renew that motion.
We're not going to establish a rule like that. That's totally unrealistic.
Sure, understandably, but in this case in particular, I think that it's unfair to place the burden on on Mr. Jones in this instance to have renewed his motion, when in fact he couldn't have renewed his motion for the 4 months that the court was sitting on it, and he did several times do the only thing that he could have done in that instance, which was inform the court that the motion was still pending, that he was having difficulty gathering discovery, that he couldn't get access to his medical records. That was all that he really could have been expected to do at that point.
All right, are you reserving the rest of your time?
Yes.
Okay, that's
Thank
fine. Thank you. Mr. Morris.
Good morning. May it please the court. Michael Morris on behalf of the defendants' appellees. The district court properly granted
May I just start you out?
Absolutely,
please?
Judge Rovner.
Thank you. Look, during the transfer, the search, the placement of Jones in the segregation cell, it appeared, that the officers were physically supporting his weight on the injured side of his body. He appeared to be barely able to hold himself up once the brace was removed. When they did go downstairs to the cell, the officers appeared to essentially carry him. So, what more would be needed to show knowledge on the part of the officers that he could not navigate the world at all without his durable medical equipment, and that he would be reduced to crawling on a concrete floor? They saw he was in a brace. They saw he was in a wheelchair. No one goes into prison with that equipment unless someone with a medical degree is deemed necessary. But they took those things away, and they left him to fend for himself in a cell that contained almost nothing. So I was wondering, that's a long way to get to it, but I was wondering why, Hughes versus Joliet Correctional Center doesn't apply here.
Well, Judge Rovner, I would say, first of all, that, the video also shows, after they placed Jones in the cell without the knee brace, he doesn't fall to the floor. He doesn't complain to Sergeant Anderson that without his knee brace, he can't move around his cell. And he stands there under his own weight, and he complains about one thing, and that's that his wrists hurt. So I don't think that it would be fair to impute that sort of knowledge upon the defendants when they're witnessing the defendant stand without any complications after they remove the knee brace. So I think that's the key difference here is based upon their observations, without his knee brace, he was standing completely fine. So I don't think that the Hughes v. Joliet case is on point here.
It was difficult to see what was inside of Jones' cell. Am I correct that the mattress was placed directly on the floor, so he would have had to somehow get up from floor level if he needed to go to the toilet or to the door for food? Is that correct?
I'm not sure what evidence is in the record about the layout of the cell, other than there's a reference in his verified complaint that the mattress is on a concrete slab that's perhaps a couple of feet high. But so I'm not sure beyond that what we can infer. But he would have had to, yes, get down to get to his bed and get up to obviously get around the cell. But again, what we see from the video is that there's no reason for any of the defendants, after they remove the knee brace, for them to suspect that he's going to be crawling around his cell. I would also question whether, as a matter of law, that given the duration of time that he's in this cell, it's a mere 2 days until he's placed back in general population, presumably with his necessary equipment, that as a matter of law would rise to an Eighth Amendment violation.
See, that video, it seems that from the video that he wasn't physically capable of walking independently up or down stairs, as he told the officers. And again, he's in a wheelchair. I mean, does the record tell us how or why he was placed in a prison where access to every cell required the use of stairs? Is he still there?
Judge Roebner, I think the short answer to your question is no. We don't know how we wound up at, I believe this was Columbia. And I'm also not sure that there's anything in the record other than a reference in his verified complaint to a wheelchair. He certainly wasn't in a wheelchair when the video starts. I don't know that it certainly seems inconsistent with the record that he had a wheelchair. But I'm not, and to answer the other question, I'm not sure where he is now. But in addition to sort of as a legal threshold, I don't think this rises to an Eighth Amendment violation. There's also no evidence that he complained to anyone about the conditions of his cell. And like I said before, Judge, the only complaint that he does make after he removes his knee brace is about his wrists. So I think that also belies his claim. And the video is equally clear with respect to his other two claims. It clearly shows that the amount of force was, in my view, de minimis, but certainly, I think, tailored to the situation, which was you had an unruly inmate who was disobeying orders, and so we had to be transported in a safe way for everyone to restrictive housing. The entirety of the search is on videotape. 3 male officers searched him. The lone female officer was standing in the back. Her view was occluded by, I counted 4 different male officers. At no point did he complain about Sergeant Dutton's presence. Despite knowing about it, she was there from the very beginning when the video first starts playing. She's there. She walks next to him the entire time outside the prison yard as they're transporting him. The search lasted for less than a minute. As soon as it's over, Sergeant Anderson hands him a towel. There was a brief moment when they're transferring him into his cell when the towel drops. They immediately pick the towel up, and you can see Anderson blocking the view of Dutton. So there's clearly no evidence that the legitimate search was done in a way to harass Mr. Jones. So given the objective evidence in this case, including the videotape, the district court properly granted summary judgment. And there's just simply nothing that an attorney, had one been appointed, could have done in the face of such evidence. So
you see, the one thing that I'm just I am conflicted about is the idea of removing someone's leg brace, and which had to come through a medical professional. and just sort of leaving him in that cell. I mean, you say only 2 days, but my goodness, if you had to crawl around, not you, but if one had to crawl around a cell for 2 days. I mean, can you help me with it?
Yeah, my best response to that, Judge, I understand your point. My best response to that would be, in the interests of institutional security inside this controlled status, you have to take that stuff away. Perhaps unless, as soon as they do, it's very clear that he's going to be suffering in pain. That's not the case here. They did not see anything. There's nothing on the video to indicate that, so I think that this is a clear call for me. But perhaps in a different case, I could see that there being some need for an exception there. I don't think that's the case here. And so that's the best answer I can give you on that, Judge. And
do we know why he was wearing a knee brace?
I do not know.
The record doesn't say anything about that?
There's nothing in the record about specifically why he's wearing a knee brace. He makes complaints about, I think he was hit by a train. He had some, he has an extensive medical history. I'm not sure exactly why the knee brace. So I'm sorry, I can't answer that question.
And we don't, and nothing is other than his testimony will tell us whether or not there was a wheelchair. Is that correct?
That's correct. That's correct, Your Honor. I'm not, other than that one reference, I don't know.
What do you think what were they worried about with the brace in the cell? That he'd use it as a weapon of some sort?
I think they were just following standard prison procedure. Anytime an inmate is transferred into this controlled status where inmates are obviously placed, this is a disciplinary segregation facility within the prison where inmates are transferred when they've misbehaved or they pose a danger to staff or themselves, that everyone is initially treated the same. They're just given a smock, and through good behavior they can earn other property, but he was treated like everyone else in that situation, and that's why, Your Honor. And I see my time is up unless there are any other questions. I thank the court, and I would ask that it affirm the district court's judgment.
Thank you.
Thank you for answering my questions.
Ms. Steigert.
Hello. Judge Rovner, just going back to your conditions of confinement questions, I want to reiterate your point that the defendants took away my client's documented necessary medical equipment when they placed him in this cell. So I would agree with you that Hughes and Powers do apply here. And as to opposing counsel's statement that it was only 2 days, while the duration of time is one factor, it is only one factor in the overall scheme of what everyone should be looking at. And especially when it comes to adaptive medical equipment, I would agree with you that any duration of time where you have to crawl around on a cell floor to access your food or to get to your bed could be considered sufficient. And these are all facts that should have gone to a jury. In particularly here, there is a special handling summary that says that my client requires this adaptive medical equipment. These defendants took that equipment away and placed him in a cell for over 48 hours without that equipment. And the fact that the court then placed the burden on my client to make a complaint is not the standard here. And then again, going back to opposing counsel's statement about Officer Dutton's presence being simply peripheral, I would disagree with her presence being peripheral. She was videotaping the entire altercation, including when my client had his buttocks searched. He was given a towel, but it was too small to cover his genitals, and it dropped multiple times, exposing him, which he testified to in his verified second amended complaint. And if we look at the Secretary's decision, which the district court completely failed to acknowledge at all, and which is quoted in my client's verified second amended complaint, the Secretary's decision actually states that they believed that Officer Dutton's presence was not necessary because no emergency existed in this instance, and That's evidence that, again, should have gone to the jury.
Thank you.
Thank you.
Our thanks to both counsel. The case is taken under advisement. And our next case for argument this morning is United States versus Pearson. Ms. Christensen.
Good morning, Your Honors. May it please the court. My name is Joanna Christensen, and I represent the appellant Byron Pearson in this matter. The district court abused its discretion by allowing course of investigation evidence to be admitted in this case by the government. The evidence at issue was statements made by DC calling the police to report that Mr. Pearson had come to our house, had a criminal history, and may be armed. She said he may come back. The district court initially limited the evidence to exactly that. Then, after opening statements, reversed that and allowed the government to put in additional facts, including that the officer believed DC was scared, the officer was uneasy, that Mr. Pearson was likely armed, and that he was threatening to shoot.
Were there any objections to those specific questions?
During the testimony, no.
Because the reason I asked that question is the following. I don't think there's any doubt here that the defendant opened the door to this. I mean, the judge told him not to do it, and then counsel did it, okay? I mean, and you know why counsel did it. They did it for a particular purpose, and they did it. And then the judge said, I'm going to let the evidence in for this limited purpose. And maybe the government did more than they should have with the maybe they milked it a little bit, okay? But there were no objections during the testimony to limit what the government let in. And then I thought that the district judge gave a very thorough and comprehensive limiting instruction right after the testimony as to how the jury could use that testimony. So what do we do with the fact that there were no specific objections to the questions? The judge, I don't think, has any obligation to cut off the prosecutor and say, wait, you're gilding the lily here a little bit. Move this along. Could have. Some judges might have, but
Right. I agree, Your Honor. I think that it was a judgment call on the defense attorney's part.
What
of
to
course.
call, right.
Do you want to bring more attention to it or not?
Right.
The judge had said he was going to give a limiting instruction. So at that point, having litigated the issue, I believe defense counsel thought that that was fine to preserve it and further. And I absolutely agree that I think the government went further than it should have in this case. And
probably farther than they needed to in this case, right? Where the defendant was arrested with the gun under his body. I mean, there was not much of a defense here, right?
Right. And this goes, a little further down in my argument, but of course harmless error is always going to be an issue here. But we keep seeing this come up over and over again where the government just goes too far with evidence it doesn't need. And then this court doesn't reverse because it's harmless error and looks at the overwhelming evidence, which I'm not conceding there was overwhelming evidence in this case, of course. But then without a reversal, the government keeps doing it knowing that they won't get reversed, the conviction will remain. And I think that's the problem that this court has repeatedly talked about in a series of cases. Now, these cases kind of run parallel. There are some cases that say course of investigation is not hearsay. It can be used in certain circumstances. And then the cases say that it's rarely relevant. And there's very little value to it because the government does not have to prove what the course of the investigation was here. And about your point about opening the door, I don't agree that defense counsel opened the door to what the judge then did. I think defense counsel walked by the door, let's say it that way, and hinted at the fact that this arrest may have been a surprise to the car stop, might have been a surprise to Mr. Pearson because of the circumstances. But then when you look at the evidence, that was never part of the case then later, and that could have been, we don't know, because then the evidence changed, it shifted because of the court's reversal of its own ruling. You know, in the cases I've distilled down that there are really three reasons this court has allowed course of the investigation to connect the dots. And I'm not sure that that is what's happening here. You know, it could have very well stayed to what the court limited it to, and that connects the dots. You know, we know why they're investigating him, and that's enough. To address officers as officious intermeddlers, and that certainly wasn't what was argued here necessarily, and nefarious conduct on the part of the officers also not argued. And then to clarify a complex investigation, that's the United States versus Law case. But in that case, the course of the investigation evidence was corroborated by other testimony. So the problem is, and in this court in Silva, that even if this testimony could come in, it was not cross-examined because it couldn't be, because DC herself wasn't called. So it implicates the defendant's Sixth Amendment rights in addition to violating the rules of evidence. And finally, this court has suggested that this type of evidence can violate Gomez. And Gomez, of course, was a case that reorganized, shall we say, the district court's 404B analysis. But it must always end with the 403 analysis. And in Mr. Pearson's case, that 403 analysis, there was nothing that changed it, and the court just changed its mind and didn't address why that portion of its analysis that made it first rule the evidence couldn't be admitted now became obsolete. There was no explanation of that in the record. So I did want to address briefly the lack of hearing on the proffer letter. I'm sorry.
Just to go back to that final point, is that actually required a rebalancing of 403 issues in this circumstance as a matter of evidentiary law? That when the defense opens the door to a previously precluded line of questioning, that the judge has to do a rebalancing under Rule 403? I don't know that
I'm
that's
not aware
required.
of any case specifically that says that. I think we have a little bit of a unique situation, although there are cases that talk about opening the door. But when then all of the evidence the court said couldn't come in now comes in, I think the analysis under 403 should happen, because it is a key part of the application of the rules of evidence and the application of constitutional law to this case. And Gomez didn't go that far, but of course Gomez didn't have this issue specifically. So I am preserving the other issue into my rebuttal time, so I'll save that unless the court has any questions about the proffer letter issue for me.
Appears not. Thank you.
Thank you.
Ms. Massa.
Good morning, Your Honors. Assistant United States Attorney Kelsey Massa on behalf of the appellee of the United States. There was no abuse of discretion here. Respectfully, I think this is a perfect scenario for where a course of investigation testimony is actually very important to fill a gap that otherwise the jury would not be able to fill themselves. And I think it's pretty clear from the opening statements that defense counsel gave in this case at trial that they were fully intending to exploit that gap in the testimony. I think this is an example of where sort of the cold record on appeal doesn't give the full picture, but the clear tone of that opening statement and the implication was that the complainant was not to be believed by, I think, bringing up the relationship. It was an ex, sort of implying it was an ex-girlfriend that maybe had some sort of agenda. I think this is a scenario where defense counsel was very clearly planning to exploit the gap in the evidence, and given the ruling that the court had previously made on the motion in limine in limiting the testimony, the government was certainly still bound by that, but given defense counsel's statement in openings, I think it was clear that that door was opened.
But, you know, I mean, the government in opening statements went farther than the district court allowed by saying that he was likely armed rather than may be armed. What do you think the defense could have done to correct the misimpression this created without violating the court's order, because that was a fairly prejudicial misstatement, given that the sole issue is whether he possessed the gun.
Respectfully, Your Honor, I don't know if there's quite so much real estate between may and likely as Your Honor may think. I think it implies, both words sort of imply a possibility that the person is armed. And frankly, the evidence that the actual facts of the case.
I really disagree with you on that, because, you know, may would be, you know, like anyone out there may may be armed, but likely, I mean, that, you know, likely, it's he always is sort of thing. I do think there's maybe a city block between the two.
Well, and Your Honor, the difficulty with this is that defense counsel did object and actually did move for a mistrial after that opening statement. The district court addressed that and stated and ruled that the motion in limine was still intact, advised both parties to hew very closely, and the government certainly would have hewed very closely to the motion in limine in eliciting testimony from Officer Minnis, who took the actual report from the complainant in this case. And so I think the problem is that defense counsel then felt that they still needed to respond, but if that's the rule that the court would allow, then that sort of allows a tit-for-tat response to motions in limine. And I think what defense counsel could have done is hewed very closely, and then the evidence that would have been elicited would have then also hewed very closely to that motion in limine. But by adding significantly more details than what the government did in opening statement, by referencing that this was a complaint, that it was a complaint from an ex, I think kicked that door sort of wide open. And either way, as opposing counsel sort of referenced in her argument, the harmless error standard, I think, is also met here. There was overwhelming evidence of the defendant's guilt, and the court gave a very thorough curative instruction. Some of the case law that opposing counsel cites in their brief, specifically Jones versus Basinger, I think is extremely distinguishable here. There was no curative instruction given in that case whatsoever. There was extensive testimony, extensive hearsay testimony regarding an informant's tip that was completely improper bolstering, and that's just simply not what happened here. If I could move just briefly to the proffer argument, I understand opposing counsel didn't get to it in hers, but I would just like to say that there was no abuse of discretion on that point.
I do have a question that sure, I would, you know, because Pearson contends that even though there was not a triggering event, he had to completely change his theory of defense because of the threat of the proffer agreement waiver. I didn't see a response from the government on that point in the brief. You know, that the waiver tied his hands in formulating a defense. And so that's what I would really appreciate your narrowing in on, please.
Sure, Your Honor. The defense did say that in some of the back and forth on the record about this proffer agreement. It's not clear from the way the trial proceeded that they were actually hamstrung in any way. Mr. Pearson did put on a meaningful defense. There was extensive cross-examination of the government's witnesses, especially focused on the lack of forensic evidence, which of course is always, I think, is always relevant, and juries are always interested to hear that. So I'm not quite sure on what defense Mr. Pearson would have put on. I don't think he's entitled to put on a defense that would have actually been false. He's not entitled to.
Did Mr. Pearson ever proffer what defense he would have put on absent the judge's ruling?
He did not, Your Honor, and that I think is a problem because we just don't know what evidence he was thinking he was going to be able to put in front of the jury that he was then prohibited from doing. Whether that was actually his testimony or testimony of another witness. We simply don't know, and I think this court has been very clear that proffer agreements are enforceable. They're very important tools that the government uses in order to get information from potentially cooperating defendants. It's in every party's interest to be able to enforce those agreements and to ensure that parties are being truthful in those proffer statements. And
in your brief on page 15, there's a footnote of, let's see, in the response brief, that the defense counsel had an affidavit from Pearson on the issue of the waiver in the proffer agreement, but it was never presented to the court. So, do you know if the record tells us why that affidavit wasn't offered?
It doesn't, Your Honor. I don't know why defense counsel did not enter that affidavit into evidence. I don't know what the affidavit says. They offered no explanation whatsoever, either on or off the record, to the government about what that affidavit would have said or why they chose not to submit it to the court.
Thank you.
And fundamentally, the defendant did not raise any substantial claim here that would entitle him to an evidentiary hearing on the issue of knowing waiver. There's nothing substantial about a defendant who simply claims that he didn't know, especially in face of a written proffer letter that has his signature on it that specifically says, I understand the agreement, and especially in light of an affidavit from his attorney that reiterates the fact that the terms of the proffer agreement were explained to him. So if the court has no further questions, the government would ask that Mr. Pearson's conviction be affirmed. Thank you.
Thank you. Ms. Christensen.
I'll primarily address the proffer issue. So the lack of defense counsel was completely tied in his hands, and we wouldn't know exactly why or how or what the defense was. And that's one of the consequences of waiver that Mr. Pearson didn't understand. And we don't know what the affidavit was. It wasn't submitted. It would probably be helpful if it had been submitted, Mr. Pearson's affidavit. But all we know from his trial counsel affidavit, his formal trial counsel, is that he understood the terms of the agreement. But it doesn't talk about the extent of his understanding, particularly when it comes to the consequences at trial of the proffer agreement. So I think there's a lack of evidence that does not necessarily skew against Mr. Pearson. And harmless error comes right in there for both issues. The overwhelming evidence, well, I think from knowledge of the case, the gun was found under Mr. Pearson, not on him, and that he would have been able to argue that it was not his gun, which he could not argue. That was essentially the only element, the possession, his possession, was the only element left open. I don't think he contested the other elements of the felon in possession statute. So the harmless error is not, as overwhelming, or the evidence is not as overwhelming as the government would like to see it is. And the introduction of an ex-girlfriend as being the complainant is no more serious than an investigation. I don't think that necessarily questions the officer's motives in whether it's an ex-girlfriend or just someone who complained. The fact is that there was a small gap, and perhaps defense counsel saw that, but it was not in violation of the motion in limine. But then on the other hand, then the government had already gone too far. So in its opening statement, talking about may have had a gun, then defense counsel has to deal with that because the agreement was likely and there was an objection to that.
I think it was the other way around.
Oh,
the agreement was
the agreement was to May. You're right. I'm sorry, Your Honor. Yeah, I do think I agree with Judge Rovner. There is a big difference between the two, so that was an unfortunate mistake on my part. But unless the court has further questions, I'd ask for this court to remand for a new trial. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. Our sixth case of this morning's calendar will be taken on the briefs, and so we are concluded, and the court will stand in recess.